Good morning. My name is Jacob Bignall, and today I'll be doing a presentation on access to justice and legal representation for all. Today, this presentation will focus on the importance of access to justice in the Queensland and Australian legal systems, particularly since they are systems underpinned by the rule of law, something that advocates for equal protection and equal binding of all citizens under the law. Then we'll move on to an analysis of the legal aid and duty lawyer systems and how these inevitably contribute to access to justice. Finally, we'll do some conclusions and recommendations on how access to justice in Queensland can be improved. I'll start with a general overview of the presentation. We'll start with an overview of access to justice, then we'll move on to the social, political, and economic factors contributing to inaccessibility. Then we'll move on to impacts of inaccessibility on the administration of justice, the legal profession, and the broader community. Then we'll do an overview of legal aid and the duty lawyer system. We'll look at the cost and benefits of these systems, and then ask for any opportunities for improvements. Finally, at the end of this presentation, we'll do some conclusions and recommendations for access to justice as a whole. So why is access to justice so important in the Australian legal system? Well, if you refer to the slide, Article 10 of the United Nations Declaration of Human Rights states that we are all entitled in full equality to a fair and public trial. Due to the complex nature of legal relationships and processes, it's almost impossible to see a fair trial without legal representation. That means that due to the complex nature of the law itself, lawyers are necessary for people to feel protected and represented by the law. This relates to one of the core principles of the Australian legal system, the rule of law, which says that everyone should feel protected and have access to the law. Furthermore, the law binds and protects all. It is important then that people feel protected and represented by the law by having access to legal professionals who can adequately communicate their interests. So what does access to justice look like in Queensland? Well, thanks to the Access to Justice scorecard done by the Queensland Law Society in 2022, we can kind of get a general understanding of how legal professionals view access to justice in Queensland. When asked to rank access to justice on a scale from 1 to 10, legal professionals answered on average a 5.02. This is quite a midfield level response, and is also quite concerning for a developed economy such as Australia, which espouses itself to have a quality and just legal system. Some of the reasons for this score were cost, difficulty in accessing legal services such as legal aid, and a lack of awareness of legal rights. Furthermore, respondents suggested that an improvement to access to justice would require an investment in legal services such as legal aid and duty lawyers and pro bono work. So we've spoken a little bit about the importance of access to justice in the Australian and Queensland legal systems, and the current state of access to justice in the Queensland system, which is admittedly quite poor. But it is also important to understand what individually and personally drives people to have access to justice. There are many social, political, and economic factors contributing to individual inaccessibility. When we look at the social aspects, refer to the slide, a lack of knowledge of the legal system, intergenerational poverty and poor education, remoteness and a lack of technology or language barriers are all social aspects that stop people from accessing the justice system. Take a moment to think. It'd be very difficult to access a system which you have never interacted with before, or which you are unable to interact with because it is primarily English, or it is in the big cities and you're out west. There are many factors that are social in nature that prevent people from accessing justice. There are also political factors. Legal aid services are often underfunded, and there is an unwillingness on behalf of the government to provide services to quote-unquote criminals. Some economic factors also include some financial restraints, such as homelessness, poverty, or providing for dependents. Exorbitantly expensive private lawyers and high court costs also limit the ability for people to access justice. And finally, of the predicted 5.6 million Australians who have used legal services, 9% of this figure have inaccessibility to financial reasons. So financial restraints is really the biggest cause of inaccessibility. And this is due to the complex nature of living in Australia's economy today. You can have children that you care for. You can still have a full-time job, but have so many different things you're paying, like mortgages, car repayments. So this makes access to justice quite untenable. So what are the impacts of inaccessibility on the administration of justice? A reminder that the administration of justice calls for the streamlining of cases whilst also reaching just solutions. So really, it's a system built of efficiency, but still one that protects all Australians. So how does inaccess affect this administration? If you look at the graph on the slide, you can see that respondents voiced that the complexity and expensiveness of the Australian legal system made them feel like aliens in the courtroom. Furthermore, they stated that the legal system was too far removed from the average person. For a system that represents over a quarter of Australians each year, these are concerning statistics. Furthermore, people of lower socioeconomic groups are often ones who face the legal system. More than 13% of Australians are in poverty, but only 8% of Australians classify for legal aid. Having no legal representation slows court processes, but it also prevents people from knowing and feeling protected by the law. This stands in opposition to the administration of justice, as it leads to inefficiency, but it also prevents people from lower socioeconomic backgrounds from reaching justice and just decisions. So what are the impacts of inaccessibility on the legal profession then? There are really two areas of the legal profession that are impacted by inaccess to justice. The first being the sustainability, credibility, and efficiency of legal aid centres and legal aid workers. And secondly, the public perception of the legal profession as a whole. Starting on the first point, lack of funding and inaccess to legal aid causes the very few legal aid centres there are to be overworked and ineffective. Finally, a lack of funding for legal aid also disincentivizes other lawyers from joining pro bono work and legal aid work, further worsening the issue of inaccess to justice. Secondly, in relation to the public perception, the expensiveness and complexity of legal relationships makes the service seem like a luxury good only entitled to rich people. This distances itself from the rest of society and frames the legal profession as one that is out of touch with reality and out of touch with the needs of our community. It is important to address inaccessibility then to reinstate this good faith with our potential clients. Finally, what are the impacts of inaccessibility on the wider community? Firstly, it reinforces cycles of poverty and inequality. People wrapped up in the criminal justice system will continue to do so unless they have adequate legal representation who can explain the consequences and impacts of the law. Secondly, unresolved disputes and lengthened court processes cost taxpayers millions of dollars each year. Third, it erodes public trust in the justice system. The complexity and expensiveness of the system leads to the public having distrust or feeling distant from the system. 4. It prevents members of the public from accessing the justice system in future. If you look to the stats on the screen, 9% of Australians stated financial reasons were the reasons they had their legal needs unmet. This has a huge impact on the wider community, contributing to a range of factors. So we've now touched on the significance of access to justice and its importance in protecting all Australians. Now we'd like to focus on some resolutions to access to justice, and these really focus around the legal aid system and the duty lawyer systems. Legal aid is legal services provided to prospective clients at a free cost that is funded by the government. These services are only available to a certain class of people and are based off socio-economic factors. Duty lawyers are private lawyers who work in private firms and take on criminal legal aid cases. They usually elect 1 day a week to take on this role and return to private work after the conclusion of this day. So why is legal aid plus duty lawyers important? Well, it's because they strengthen the rule of law by encouraging equal and fair representation for all. It really reinstates the idea that no one is above the law and that everyone is entitled to feel protected and covered by the law. They protect vulnerable Australians who may not have access to private and more expensive legal services. It strengthens the rule of law by ensuring that law is known and people are punished fairly. And finally, it encourages fair and prompt trials by allowing professional lawyers to lead cases. Really, legal aid and duty lawyers are important because they offer a free alternative to those who may not be able to afford other services. As with any system, there is going to be cost and limitations of legal aid and duty lawyer systems. Starting with legal aid, it utilizes taxpayer dollars that some could argue could be better spent on other government services, especially when used to defend repeat offenders. However, it is also important to note that every person is entitled to effective defense. Secondly, the strict eligibility criteria of legal aid means that thousands of Australians go unprotected, even if they are of poverty or lower socioeconomic status. And finally, underfunding leads to tired and overworked legal aid workers, disincentivizing people from joining the trade. In terms of duty lawyers, private lawyers may take legal aid cases less seriously than their private clients. This leads to ineffectiveness and a poor defense. Secondly, it adds extra workload onto already busy private lawyers. Despite these limitations, the benefits of the legal aid and duty lawyer systems obviously outweigh the negatives. In terms of legal aid, it allows less fortunate Australians to access qualified individuals, it reduces costly and timely trials, and it prevents recidivism by creating positive legal relationships with repeat offenders. In terms of duty lawyers, it provides high-end private criminal defense lawyers to lower socioeconomic groups. It fosters a sense of community between the legal profession and those who are less fortunate, and it increases the jobs available to law firms. In general, it really bridges the gap between the complexity and alien nature of a legal profession and the lower socioeconomic groups and average person. It makes the legal profession much more approachable and accessible. In order to understand the dynamics of the duty lawyer system, a case study of Skews Graham criminal lawyers will be conducted, the place where placement was undertaken. In Toowoomba, there are 5 law firms that all elect one day of the week to be known as the duty lawyers. These lawyers go to the watch house and communicate with prospective clients free of charge, being funded instead by the government. These lawyers then go up to the court and communicate the interests of the client to the magistrate or judge. At the end of the day, the duty lawyer will resign and return to private practice for the rest of the week. This system allows high-end criminal lawyers who usually engage in private work to defend lower socioeconomic groups who cannot afford a lawyer. So what are some opportunities for improvements to legal aid? Well, the most major of these is more funding, increasing public knowledge, and expanding who is eligible. Finally, diversity training for lawyers is important to ensure that they understand the impact that socioeconomic factors have on their clients, and that they can learn to bridge the gap between the highly prestigious legal profession and the average citizen. More funding is obviously the most important of these 4 points, as underfunded legal centres leads to overworked staff and ineffective representation. Doing a comparative analysis on Australia's access to justice to other jurisdictions is important to understand where Australia sits on a global standard. If you look at the maps, you can see that Australia has a high level of legal problems, but also a relatively good score in integrity and capacity. High level of legal problems is a good thing in terms of this argument, as it indicates that people feel that competent enough to engage with and participate in our judicial system. Compared to other nations that are less developed, you can see that legal issues are less common. Finally, if you look at the development of Australia and its integrity and capacity, it is quite high compared to other nations. This indicates that people feel they have access to the system and that the system is designed adequately to protect people's interest. However, it does fail to recognize that Australia is a rich nation and that the institutions and systems are tailored towards people who already have wealth. It fails to protect people of lower socioeconomic backgrounds who may be victims of intergenerational trauma. So what recommendations to increase access to justice and improve legal aid can be formulated? The most obvious solution is improving access to legal aid services and expanding the duty lawyer system. Further key recommendations include expanding rural services, encouraging pro bono work, and changing government requirements for legal assistance. You can see in the slide below some graphs showing some other solutions, and these have all been generated by Queensland law professionals under the Queensland Law Society. So what can we conclude about this presentation? That access to justice is a cornerstone of our legal system, and it allows cases to be solved promptly and protects vulnerable individuals who may be of lower socioeconomic backgrounds and cannot afford formal legal representation. Legal aid and duty lawyer systems are extremely effective in improving access to justice, as they provide free legal representation. And finally, funding and eligibility criteria must be reformed for legal aid to be completely effective. And finally, if you would like to pause and read the bibliography. Thank you for listening to this presentation.